I am Zoe with Celebration Magazine, and we are here for a very special Zoom and Learn today. We are going to be talking about incapacity and special needs planning, both very important topics to plan for your life and what you're going to do for other people and how you're going to take care of them. So without further ado, I am going to mute everyone and I'm going to turn things over to Brandon. Brandon, don't forget to unmute yourself, okay?
Okay.
Great. All right, Brandon, the floor is yours.
Now we're unmuted.
Okay, so we're going to get the split screen going here. So give us one few seconds, guys. Okay.
Okay.
Okay, guys, so we are going to be talking today about two really specific topics within estate planning. So this isn't really a global look at estate planning. I've done that in the past through Celebration, but we're looking more at two niches here. One is planning for the possibility of mental incapacity. And so this can be different things. Somebody could end up with cognitive decline, Alzheimer's, dementia. Somebody could have a head injury from an accident, a car accident, or a fall, and have, be in a coma or have some mental impairment. Or somebody could maybe have a stroke, and one of the outcomes of that is mental impairment that may or may not improve. So we're going to talk about how to prepare for that. And then also we're going to talk about planning for special needs. And this means special needs beneficiaries. So if you have a child, an adult child, or a grandchild who has special needs, we're going to take a look at some topics that are very specific to that. So, and so that you guys know, oftentimes, if I present a seminar live, I'll provide some written materials to the attendees. And if any of you guys would like those materials, you can contact us in the ways you see here on the screen, and we'll be happy to forward those to you. So a little bit about myself. So I am the owner of the McGee Law Firm. We're an estate planning firm. We have an office in downtown Fort Worth and an office in Southlake. Estate planning and elder law is what we do. We don't, practice 5 or 6 areas of the law. This is what we focus on. It's what we do day in and day out, and it's what we really enjoy. I'm from the DFW area, grew up here, born and raised. Went to TCU in Fort Worth, where I studied history and political science. Then I went to Atlanta. So I left Texas for 3 years, went to Atlanta, Georgia, attended Emory University School of Law. And I've been licensed and practicing in the state of Texas since 2002. I'm also a member of the National Academy of Elder Law Attorneys and the American Academy of Estate Planning Attorneys. And we'll look at that. So why is this important, these professional organizations that I'm a member of? Well, the American Academy of Estate Planning Attorneys is an exclusive organization that only allows in a certain number of members per region. Currently, I'm the only member in the DFW area. There's several others in Texas, others all across the country. But what's important to know is that when you're hearing an academy attorney speak, or if you hire an academy attorney, that you have an estate planning attorney who has been highly vetted and who focuses their practice in this area. We're not attorneys, again, that practice 5 or 6 areas of the law. This is what we do. Also, NALA, National Academy of Elder Law Attorneys, another great national organization that I'm a member of, that provides us a great network. This one is not limited, really. So there's a lot of members in this one, because as long as if you're an attorney and you have a license and you pay your fees, they let you in. But there's a lot of great practitioners across the state and across the country that we can network with, and they give us a lot of great up-to-date information on changes in the law, trends in the law. Our firm, we're also a member of the Better Business Bureau, where we have an A+ rating. And so let me talk for a minute about why I am an estate planning and elder law attorney, because obviously there's a lot of different things I could be doing as an attorney. And I'm sure all you know that. Lots of different areas of the law. And so when I was applying for law school, when I was in law school, when I left law school, being an estate planning attorney was nowhere near on the agenda. In fact, if you had told me that's what you're going to end up doing, I think I would have thought, well, that sounds really boring. That's not exciting. I don't think that's what I'm going to end up doing. What I wanted to do when I was younger was I wanted to be in the courtroom. I wanted to be a trial attorney. I wanted the excitement and the fireworks, and I got it. So for about 10, 11 years, I did a lot of litigating, a lot of trial work, and at first it was exciting. It was fun. It was an adrenaline rush. It was thrilling. But this is my family here. That's my wife, Rita McGee, who's a real estate attorney here in Tarrant County, and our fraternal twin sons, Cole and Hunter. But once I got married and started my own family, and really once I had kids, and they started getting, growing up and getting a little bit older, I started really kind of getting burned out on trial work. It's stressful. It's time consuming. I got to the point that it was not something that I wanted to spend the rest of my life doing. I was really sure of that. And I wanted a kind of a better quality of life at home where I wasn't stressed out and tired all the time, basically. So I started thinking about, I had a smaller probate and estate planning practice. Probate goes hand in hand with estate planning. It's a part of it. And I started thinking I really enjoy that because it gives me an opportunity to help my clients set things up so that when these bad things happen in life, people are going to pass away, people are going to have to go to nursing homes, people are going to become mentally incapacitated. A lot of these things are going to happen in everybody's family. But with good estate planning, you can set things up so that your family has the easiest time possible managing the situation. And a lot of train wrecks can be avoided. Especially blended families are a big red flag for people who need very comprehensive, thorough work, and just any family really. We've seen traditional families where the kids get really ugly with each other after the parents are gone, and so I started thinking about this, and then a few months later, in the year 2012, my wife Rita, at the age of 39 at the time, was diagnosed with stage 3 breast cancer. And our twins were about to turn 4. This was May of 2012. And this obviously, I had a practice, she had a practice, we have our young kids, we're blowing and going, and life's busy. And this was the last thing we expected. So this really devastated us. It was a very devastating, obviously for Rita the most, but for me, for my kids, for our families is very devastating. So Rita immediately started going through chemotherapy, and of course, she had other things she was going to be doing with surgeries and with radiation, and but she started going through chemotherapy, and then about 35 days or so after she started chemo, on July 1st of 2012, my father, at the age of 64, died of a massive, sudden, completely unexpected, out of the blue heart attack on a Sunday afternoon, July 1st, 2012. At his home in Dallas. So within about 35 days, I had lost my father unexpectedly, and unexpectedly, my 39-year-old wife had stage 3 breast cancer and was going through chemo. So I really started thinking a lot about life, right? This causes you to really reflect when these things suddenly happen to you, particularly at, I guess, maybe a fairly young age. We're going through these things. So I came out of that year thinking, what, life can be short. We don't know when our last day is going to be. We might as well wake up every day and be excited and be happy to go do what we do for a living, which I hadn't been in a while. So that's when I decided to refocus my practice completely away from litigation and focus on estate planning and elder law. And that turned out to be one of the best decisions I've ever made. I love what I do. My staff enjoys it. It's great. But best news of all is Rita has been what they call no evidence of disease for 8 going on 9 years now. So that's the best news. But that's why I'm an estate planning attorney. I really enjoy I kind of call it preventative law, like we have preventative medicine. I enjoy helping families set up so that when these things happen, people get sick, people pass away, people lose their mental capacity, the family has the easiest time possible managing these situations. So just so you know, at the very end, I will answer any questions you guys have. So as I'm going through this, you might want to write them down if something pops in your head. If you're like me, pops in your head, you don't write it down. 5 minutes later, it's gone, right? So please write that down. So incapacity planning, what we want to do is this. Basically, if I lose my mental capacity, if let's say that I'm in a car accident tomorrow and I'm in a coma, and it's, again, this is very black and white. There's no way I can make decisions for myself. I can't make healthcare decisions. I can't manage my finances, manage any of my personal affairs. If my wife does not have something in place, a plan in place for that, what's going to happen? What's going to happen is, or my adult child, if somebody's single, this would be an adult child, stepping up. My wife is going to have to go hire an attorney like me, spend several $1,000s to go through a court process called guardianship. It's through the probate courts, so that she could get the permission to make my medical decisions, get my medical records, manage my finances, sell the house, sell the car, whatever it is she feels like she needs to do. She's going to spend thousands of dollars in court and many months in court just to get that authority. In the meantime, if I'm in a blended family and I have children from a previous marriage, and they're adults, they may be filing in as well and having a legal battle, a legal dispute with my wife. Okay. So in a best case scenario, you're spending several $1,000s and it's taking several months. In a bad scenario, you're spending a lot of money. The sky's the limit with litigation, and it could take a year or two to get through, or longer. Now, what is the solution to this? If I want to set up so that if something like this does happen to me, or if it does happen to my wife, that the other one of us can immediately step in. We don't have to hire an attorney. We don't have to go to court. We don't have to spend any money. We just step up and we make the medical decisions day one. We get medical records if we need to. We sell the house, we sell the car, we access financial accounts, all those things that we need to do in life. That's a series of documents called powers of attorney. Okay. So we're going to look at that here, but powers of attorney is the solution to this. And when it comes to power of attorney, number one, you obviously need to be mentally competent whenever you sign any legal document. So if somebody brings somebody to my office and it's clear to me that, let's say they have Alzheimer's, and it's clear to me that they don't understand what they're doing, I can't let them sign. Okay. So I want to say, well, I'll say two things. Number one, it's important, if you don't have powers of attorney that were drafted by an attorney in Texas, so we're not talking about out-of-state powers of attorney. We're not looking for do-it-yourself type documents. We're looking for documents prepared by a Texas lawyer, I believe, personally, within the past 5 or 6 years, because the language will become outdated. Then you should certainly go soon and get powers of attorney. Get a good set of that for you and for your spouse if you're married. It is a fraction of the cost of going through the court system, and it's a million times quicker. It's the speed of light compared to the court system, and a lot less stressful. But if you have those in place, what's going to happen is that spouse, say in my situation, my wife can immediately step in and just handle everything. So make sure that you have those in place. And particularly for people, if you or a spouse, or if you know somebody that has received a diagnosis of dementia or Alzheimer's, but they're still in the early phases, that's huge red flag. Get this done now. And in fact, that's where you need to get everything done. Whether it's a trust or a last will and testament, certainly powers of attorney. Those things need to be done immediately while that person still has the ability to sign legal documents. So let's kind of take a look at this a little bit more. Some of the powers of attorney, you know, what do they do, right? What do the different ones do? Number one, there's a property power of attorney, which will allow somebody to transfer your real estate. So there's two that work together that we use in Texas: property power of attorney and statutory durable power of attorney. And between those two powers of attorney, it should allow the spouse or the family member to do just about anything they need for that incapacitated person: sell real estate, lease out real estate, handle tax matters, sell the car, have the car sticker, you know, the registration renewed, manage finances, pay bills, receive income, engage in lawsuits on behalf of the incapacitated person if that's necessary. So the property power of attorney and the statutory durable power of attorney are things that everybody should have that allow management of a person's estate. Now, are assets. I almost kind of hate the word. I don't hate the word estate personally, but a lot of times when I say the word estate to non-attorneys, to my clients, they kind of get this image of the Rockefellers or the Bass family and you know, Bill Gates and Warren Buffett. And I don't have an estate. That's what people who have, you know, $500 million, they have an estate. We all have an estate. When I say estate, that's your, you know, if you have a house, your car, and a bank account, that you have an estate. Okay. Statutory durable power of attorney, I just talked about that. That's what allows people to handle any manner of decision making as it relates to assets. A living trust. So if you, I'm not going to get deep into trust today. It's not really one of the main topics here at all. But if you do have a trust in place and you have assets funded into your trust, connected to your trust, and you become incapacitated, your successor trustee can step up and manage those as their role as the trustee. So somebody with a trust, some of the assets may be managed by the trustee, some of the assets may be managed by the POA. Normally it's the same person though. But keep in mind, if you have a trust, that also will take into account incapacity management of assets if you're mentally incapacitated by the trustee. So anyways, that's another advantage of having a trust. So essential planning documents for healthcare. So we're going to take a look at these documents. And basically, this is pretty simple initially right out of the gate. If I lose my mental capacity, I need somebody to make my medical decisions. Things like, am I going to have this surgery or not? Which doctor is going to treat me? Am I going to take this medication or not? And so this is something that's real bedrock, real critical to have. Also, a lot of people think that, well, I'm married, and so if this happens to me, my spouse will make my medical decisions. Technically, under the law, your spouse does not have the right to do that. Them being your spouse does not give them healthcare decision-making dominion over you if you're incapacitated. That being said, from what I hear from clients when going through things, especially I think in a hospital setting, not so much in a doctor's office, you know, somebody that you go make an appointment and go visit, but in an emergency hospital setting, sometimes the hospitals, from what I hear, do play fast and loose with the rules. And if it, you know, somebody's taken in on an emergency basis, a family member's there, it may even just be an adult kid. Even if they don't have a healthcare power of attorney, they may turn and say, what do you want to do here? I hear that not infrequently. However, even though that's the case, you don't want to rely on that because it's not how it's supposed to be. And so you want to have the healthcare power of attorney. And then, like I said, also the non-emergency doctors, they're usually a little bit more tedious about getting a healthcare power of attorney before they let you intervene on behalf of that person. Also, to kind of back up on this topic, with the property power of attorney and the statutory durable power of attorney, banks, title companies, financial companies are strict to the point of being paranoid when it comes to letting somebody access assets. It's just not going to happen. So even though in the hospital, in the emergency setting, they may play fast and loose and let you make decisions even though you don't have the right document, that is not going to happen at a bank. It's not going to happen at Schwab or Merrill Lynch. It's not going to happen with Social Security or the IRS. There's not going to talk to you, period. Even if you're the spouse, if it's not a joint account. So, like retirement accounts, for example. So very important to know that you want to have these documents. You don't want to risk getting burned and having to come hire an attorney like me, spend $7,000 or $8,000 in a best case scenario to become a legal guardian. So again, medical healthcare power of attorney, bedrock document, allows decision-making ability on behalf of the incapacitated person. We also need with this the Hipaa authorization, and this was required by federal law a number of years ago. And the purpose of this is, pursuant to federal law, even if you're a medical power of attorney, even if you're a spouse, you are not supposed to have access to the medical records of the incapacitated person unless you have their express written authorization signed on the document. So you need Hipaa to work with the medical power of attorney. If I have a medical power of attorney for my wife and I don't have Hipaa and she's in the hospital out of it, they will let me make the decisions at the hospital. What they will not let me do is get the medical records and take them off site to another hospital or another doctor to get a second opinion. So very important to have Hipaa. Advanced directive, also kind of informally called a living will. This is where you tell a doctor in certain serious situations of, if I'm on life support, I would either want to be removed or kept on. And so, we have our specific forms, they're worded a certain way, but this is where you can state your preference. And again, not just, well, I'm on life support, pull me off, because a doctor might think that you have a reasonable chance of getting better, getting out of this medical mess and leaving the hospital and, living a normal life one day. This is in certain very serious circumstances where the doctors think it looks very, very bleak. You can elect to be removed or kept on. If you don't have this document, it's okay. If you have the medical power of attorney, that just means that your medical POA would make that decision for you. So having this document takes that decision making out of your POA's, your power of attorney's hands. Is that good or bad? There's not a right or wrong answer there. My clients are all over the board with what they want, and it depends on a lot of different factors. So something you want to look into, something you want to consider, it might be right for you, or maybe it's not a right or wrong answer there. Last will and testament. The main point on this is that a last will and testament does not have anything to do with decision-making authority while you're alive but incapacitated. And to clarify even more, the POAs only apply if you're alive but incapacitated. As soon as, if I'm running around town using a POA on behalf of my mom, and then I get word that she's passed away, I am supposed to immediately cease using the POA. The POA dies with the person. A last will and testament is something that would take over after a person dies to run through the court, take through the court system to get the authority to distribute their possessions, their assets after they're gone. Okay, so it does not help with an incapacity issue at all. So it's something very critical to remember. Also, just a little tidbit: a will sends you through the court system. A living trust allows you to avoid the probate court system. Planning for one who is disabled from birth, afflicted during their lives, or resulting from an injury. So we are moving on from incapacity, and we're getting into special needs. Okay, so these are people who are disabled. It could be physical, it could be psychiatric, or it could just be mental. But for somebody who is disabled, what are the issues here? Why is this even an issue, right? Why is this something that we even need to bring up? So we're going to talk a lot about special needs trust. So here's the reason it's important is if I have a child or a grandchild who has special needs, and I either know for a fact, or I think there's a reasonable chance that they're going to end up on Social Security disability and Medicaid for their health care simply because they don't have the ability to support themselves. That is a big problem in the term of an inheritance, because let's say if I'm on SSDI and Medicaid, and this happened to a client of ours a few years ago, and my mom leaves me $100,000 in an inheritance. So I get the money from the trustee or from the executor. I have to report that to Social Security. Social Security is going to kick me off of Medicaid. They're going to kick me off of SSDI. They're going to require that I spend every dime of that $100,000 down to $2,000. Then I can reapply. So I'm basically going to have to squander my inheritance, then reapply for Social Security, disability, and Medicaid. And just so you know, the goal theoretically of the amount of money that they give you is to cover room and board, clothing, food, and most of your healthcare costs with the Medicaid. Okay. So, and again, when you're looking at this, I have some clients, they'll say, well, I have a special needs grandchild, but her mom or the dad is, my son or daughter who's the parent of this child, they're absolutely fine. So I don't need to worry about that. But actually you might, because if your son or daughter predeceases you, ordinarily my clients will refocus the inheritance to the grandkids, right? So if something happens to my sister, my mom would send, my sister's half of the inheritance to her children rather than to me. That's very common. So if you have a special needs child, adult, minor, special needs grandchild, an adult or a minor, doesn't matter the age. This is something that we really want to take into consideration is a special needs trust. And so what is the solution to this problem where if the special needs person receives an inheritance, they get kicked off SSDI and Medicaid, they have to squander the resources, paying their bills every month, then they can reapply. It's a special needs trust. So basically we want to reroute that beneficiary's inheritance to a specific special needs trust rather than giving it to them themselves directly. Because if it goes to a trust on their behalf, rather than to them as an individual, they will not be removed from Medicaid and SSDI as long as the rules are followed within the trust, okay? So very important, special needs beneficiaries need a special needs trust so they can keep their government funding that reflects the fact that they have a disability and can't earn a living themselves. So some of the pitfalls: you don't need to disinherit your child. Relying on your other children to provide for the child with special needs. I've had some people come in and say that, well, I'll just leave all the money to, my daughter and she'll handle it and she'll take care of them. Number one thing I've learned from this profession and watching and all these different things and different people and families and having people come in and complain and share their stories is at the end of the day, you just don't know who you can trust and who you can't. So, if mom is going to leave money to sister to take care of special needs brother, unfortunately, there's not a guarantee that that's going to happen. Sister can walk with all the money, not do one thing for the brother, and there will be no ramification from that. On the other end, if the sister is going to help the brother, she'll be limited in her help to no more than $15,000 a year due to the IRS gift tax. So that's just a bad plan. It's kind of a cheap way. What's the best way to put this? It's kind of like putting duct tape on PVC pipe instead of actually calling a plumber to get the job done right. Okay. So we don't recommend that. So there are 3 types of special needs trust. And again, this is the solution here. And we're going to focus on one type. I'm going to tell you about the 3, but really out of these 3, 98% of the public, the people I interact with, just need one type. So we're going to focus on one type. But first party trust, that's somebody that sets up a trust for themselves. This would normally be somebody that has a physical incapacity, and they receive SSDI, they receive Social Security. Maybe it's somebody that was injured physically in a bad accident. they can never work again, but they have their mental clarity, their mental ability, so they set it up for themselves. I don't see that very often, so we're not going to talk much about that. Pool trust, again, one I think I've never set one of these up, to be honest. But these can be established by a nonprofit organization or charity to benefit multiple beneficiaries. And so these are for, if you run a nonprofit organization or a charity, maybe this is something that you want to look into, but for most people in the public, it's not what they're concerned with. Third-party trust. This is the one that we're going to focus on. This is the most common. This is where somebody, a parent or a grandparent, comes in and sets it up on behalf of the incapacitated person. Okay. So this is what I see 98, 99% of the time, created by a third party. So again, special needs, and this is not, if somebody is disabled in some way, shape, or form, but they can work, they can earn a good living, solid living for themselves, and they're never going to apply for SSDI, Social Security Disability, and Medicaid, you don't need to worry about this. Okay, so this is for individuals who we either know or we think there's a decent chance they will end up on SSDI or Medicaid. And so the beneficiary obviously is going to be that special needs person. The person who's on SSDI or potentially on SSDI, they'll be the beneficiary. Now, we can have alternate beneficiaries who can be the siblings, for example, the brothers and sisters of the special needs person. And we'll say once the special needs person passes, all these assets get immediately distributed to the other family members or whoever you choose. Okay. And so again, we've got, we look at things here with a special needs person. They need their lodging. They have their federal and state benefits, Medicaid for the health insurance. So these are some different laws about Medicaid. Medicaid also applies, many of you may know, in a nursing home situation. If somebody needs to go into skilled nursing, they're under certain minimums. Okay, that's a top. I think I've done that topic here for Celebration in the past, but it's a topic for another day. That's not what we're talking about. We're talking about people under 65 who have to have it for health care, and then the SSDI, the funds from Social Security. And so basically, again, the way it works is this. Instead of the individual receiving an inheritance, their special needs trust receives the inheritance. The trustee is going to be the person that controls the trust on behalf of that special needs person. So it has to be a third-party trustee. The special needs person cannot control their own trust. It can be a parent, a guardian, a sibling, a friend, a professional trustee. It can be anybody that's over the age of 18 and competent, okay, mentally competent. So, but you have to have that third-party trustee. And with these trusts, the federal government releases a list of items that the money can be spent on and items that it cannot be spent on. And we're going to look at that here in a minute. So we're not going to get rolling into that right now. But we need a trustee that is organized and thorough, will keep up with an attorney, talk with an attorney from time to time to know what we can spend money on and what we can't. Because if the trustee screws that up, and Social Security figures that out, that beneficiary is going to lose the exempted trust status. They're going to have to spend all the money in the trust on their rent, their food. They're going to get kicked off disability, and they're going to have to reapply when they spend all the money. So we want a rule follower. We want somebody who's thorough and organized to be in charge of this. So again, ideal trustee, somebody organized, thorough, used to handling business, somebody who's honest, right? With a trustee, that's always huge because somebody can be robbing a trust blind and people may not find out about it for months or years even. So he's very honest, very thorough, very organized. But let's look a little bit at what are some of the things that we can spend money on and what are some of the things that we cannot spend money on, okay? Okay, so number one, we cannot give cash out of the trust to the special needs person. We're not going to go to the bank or the ATM machine and get $500 and give it to them. That's going to put them over limits for things, for their monthly income, maybe potentially tip them over the 2,000 mark for their assets. So we do not give them cash. Okay. So we need to be very clear about that. Also, we cannot give them money for food, for clothing, or shelter. So we can't pay their rent with the special needs trust. We can't buy them food with the special needs trust. We cannot buy them clothing for the special needs trust. We cannot give them cash. And then also, we cannot pay for their health care if it's something that's already covered by Medicaid or some sort of available insurance. Everything else we can pretty much spend money on. Okay. So we're going to look at that. Any distributions from the trust should be made directly to the supplier of the goods, meaning we don't hand money to the beneficiary and say, here's $500, you go buy it, you get online and order it. We need to do that ourselves as the trustee, and we need to pay the third-party vendor, the company, directly from the trust funds. Okay. And again, like I said earlier, you can pay for medical situations, medical care, medical appointments, medical things, things you need to go buy at Walgreens out of the trust if it's not covered under an existing, Medicaid policy or some kind of an insurance policy. If it's already covered, we don't spend money on it. Okay. But anything that we need that is not going to be covered by Medicaid, so this could be going to Walgreens and getting cold medicine. This could be going to Walgreens and getting Advil, going to Walgreens and getting bandages. So things that are not going to be covered, we can go ahead and the trust can directly purchase those items. Okay. If the beneficiary owns a home, we actually can spend money on repairs for the home. We can't pay the mortgage for the home, but we can pay for any repairs out of the trust. Reading, if the beneficiary is somebody that has the capability to read and likes to read, we can buy them books, ebooks, things like that. If the beneficiary is somebody, again, that has the mental capacity to attend educational courses, school, we can pay for all of that. The transportation, the books, we can help them better themselves through education if they have the capability to do that. Okay, so we can use the trust funds for that. Also, this is kind of surprising to a lot of people. Entertainment, they can go to sporting events. The trust can pay for that. Movies. So, things like that are entertainment involved can be paid for out of the trust. There are limits to this. I mean, if we say, well, it entertains me to, take a cruise of the, or let's buy a yacht so I can cruise the Caribbean. Well, the yacht's going to be an asset. It's not going to work. So, but basic entertainment, things that normal people do are fair game to spend trust money on that. And by the way, the trust can also pay for the chaperone. If the person needs somebody to go with them to the entertainment items, then that can be paid for out of the trust. Another one that kind of is surprising to a lot of people is travel within the United States or to visit friends or relatives. Then the trust funds can be used for that, and the chaperone can be paid for their trip as well. I've had a lot of clients who, I don't know about a lot, but I've had a few clients who have children with Down syndrome and adult children with Down syndrome, but they absolutely love to go to Disneyland, or they love to go to Disney World or Universal Studios. They just absolutely love it, and they're on SSDI, they're on Medicaid. And they have a special needs trust. Their trustee can take them, and they can take them to Disney World. They can spend a week there, and they can pay for the trip for the beneficiary and for themselves. So, or go to the beach. So it's pretty nice actually of our federal government to allow that, but that's allowed to be paid directly out of the trust. A vehicle for the benefit and use of the beneficiary. So this is normally going to be used for transportation, for somebody to transport that person. Usually I guess maybe not always, but normally a special person receiving SSDI, either physically or mentally, may not be in a position to actually drive a car, although there are exceptions to that. But a car can be purchased by the trust funds to be used by the person that would transport them different places, or if that beneficiary can drive themselves. Household good and other items of personal property of reasonable value not to exceed $2,000. So if somebody needs a new couch, somebody needs new dishes, somebody, needs a new chair, a new table, that can be paid for out of the trust as long as we do not exceed $2,000 a year on payment for those things. Okay. Cleaning supplies, paper products. So we can't buy food at the grocery store. We can't go to Sam's and buy a bunch of food using the trust funds, but we can buy cleaning products, paper towels, toilet paper, things like that. So you see why the trustee here needs to be really on top of it, right? They can't make a misstep, or they really, they risk just really messing everything up. So support devices, dental care, physical therapy, massages, other medical costs, like we said, not covered by Medicaid. Those things can be paid for directly out of the trust. Home care services. So, if somebody needs to be bathed, if somebody just needs their home cleaned, things that are not covered by another program that somebody needs in terms of home services, maybe having somebody come wash your car. Those things can be paid for out of the trust. Also, things that are not directly related to food, clothing, and shelter that can be purchased. So television, radio, and cable service, musical instruments, stereos, televisions, travel, education. Just kind of recapping here: recreation, entertainment, and home maintenance. So there's a lot of things that can be paid for out of the trust. And the wonderful thing about this is, for that person that has this trust, that special needs person, they will keep forever their disability check. They will keep forever their Medicaid. And they have this trust here to pay for these other items. The unfortunate special needs beneficiary that inherits directly, again, they lose their funding from the government. They spend down every dime, up down to $2,000 of their inheritance. Then they have to reapply, and they have nothing left for the rest of their lives but the Medicaid, but the check from disability. So I think most of you can probably see it is super critical for, if a family has a special needs member, to set up the special needs trust for that person. And another tip is, it's not enough just to set up the special needs trust. You have to change your estate plan to direct their assets to the trust, so that it doesn't go to them, so that it doesn't go to their brother or sister. It needs to go to the special needs trust. Okay. So reasons for a special needs trust, again, to kind of recap: we do not want to lose Medicaid. We do not want to lose SSDI. Then we lose all of our assets. And after we get to the end of all of our assets, then we reapply. We just want to avoid that. And it provides for such a better quality of life for that person, to always have that money there that can be dipped into by the trustee to pay for these extras in life. The entertainment, the travel, the car, is something that, I think usually if the person has the capacity to understand it, it makes them feel better that they know that's there. And even if they don't, they still get that benefit of a much better quality of life. So now, if you have any questions, so we're to the end. If you have any questions on anything that I just talked about, or if there are some things that I didn't discuss that you have questions on, I will do my best to answer those. And I'll let you guys know also, just to kind of promote myself a little bit, I always offer a complimentary 1-hour consultation to any individual or any family. So if you'd like to talk to me, the first hour is on the house. Past an hour, we need some sort of a contractual arrangement, but we're happy to sit down with any individual, any family, no cost, no obligation, whether you have special needs, a special needs person in your family or not. Okay. Just period. If you'd like to talk about your estate plan, you'd like to talk about a trust, a will, powers of attorney, long-term care planning, please give us a call at the number you see on the screen, and my staff will be happy to set that appointment for you, and you'll meet and talk to me personally. And also we do this for other groups, guys. So if any of you are members of clubs or organizations that you think would enjoy a presentation like this, I have different ones. Like I said, I have ones that are very global and kind of touching on all the bases of estate planning, kind of my standard one. I also have a presentation that's very specific to long-term care planning and Medicaid and preparing for the cost of long-term care. So anyways, if any of you guys are members of groups or organizations and you think they would appreciate that, reach out to us and we're happy to facilitate that. And I think there's, with the questions, put on glasses here to help me out.
I'm gonna stop your screen share, Brandon. I'll read them off to you so you don't have to wade your way through, because some of them were sent private to me. So I want to make sure.
Okay, one second. Mitch is going to come in and help me stop the screen share to make sure that it's done correctly. So
well, I stopped it on my end. So
it's already stopped.
You just have to reduce the program now that you can see.
Go to speaker view so I can.
Yeah.
Okay, perfect. Thank you so much.
All right. So, okay. Okay. Sharon, do you want to take yourself off of mute? I want to make sure that I'm giving the correct information. Go ahead, darling.
I did take myself off. Okay. I do have a special needs grandson. He goes to my possibilities. He is on Medicaid. He is a Fragile X, 28-year-old in August. And when he speaks, the speech is not recognizable most of the time, and he doesn't look at you. He can take care of himself physically, which we're very thankful for, and he's a dear, sweet young man and likes to help around the house. But I am very interested in looking into a special needs trust.
Okay.
So
yeah.
I would like to set up an appointment with you, and I will give you a call.
Yeah, wonderful. And what you just described is sort of a textbook situation of somebody that really should be looking into this topic so that he can have, again, the best quality of life possible. Yeah, if you wrote down the number, please give us a call and my staff will be happy to set that up. Absolutely.
Okay. Thank you very much. It was very informative.
Yeah, Sharon, thank you so much for joining us today.
All right, so we have one here that was sent to me, so you can't see this one, Brandon, but the first question is, why can't any of the money be used for food?
The really short answer is because that's what the government says. Okay. I mean, honestly, it's, like, why can't I drive over 45 miles an hour on this road? Because the government said you can't.
Right.
That really is the simple answer. But why would the government say that we can't pay for food and clothing and shelter? I think it's because they anticipate that that's what the SSDI check is going to be used for. And what they don't want is this. They don't want somebody who inherits, and because this can happen, they don't want somebody to inherit $5 million and, live in a 5,000 square foot house and be receiving SSDI.
Right.
Okay. If you have that much, if a family has that much money, then I think the thought is that the family can just take care of that person, and we don't need SSDI. So I think it's to dissuade people, families maybe who are very wealthy, from going ahead and collecting on that check and then, putting the beneficiary up in a home in, Highland Park. Right. So I think that's why that they limit it with food, shelter, and clothing. They want for the check, the SSDI check, to pay for those items, and then for the trust to pay for some of these other items. So okay. I'm not saying I agree with it. I don't know if I do or if I don't, but I think that's the reasoning there.
Okay. Can it be used for assisted living or skilled nursing not paid for by Medicare?
Okay, so yeah, this is completely different. Assist Number one, Medicaid. Typically, when we think of Medicaid, we think of it as a senior needing skilled nursing, and Medicaid is going to pay for the skilled nursing. Okay. Medicaid, just so you guys know, will not pay for assisted living.
Right.
Basically, they do have the state of Texas has kind of a side program where you can potentially get money for assisted living, but there's a huge waiting list. I think it's like 18 months normally. So this has nothing to do with a nursing home situation, what we're talking about today. The Medicaid that we're talking about today simply relates to somebody who's on SSDI will also, their healthcare expenses will be covered generally by Medicaid. So different topic, same organization, Medicaid, but different function and different topic.
Okay. And so can the funds be used for transportation to doctor's appointments?
Yes.
Okay.
So if somebody, it can, and like I said, on the extreme side, the funds can be used to purchase an automobile for another person to drive them places. On the less extreme side, it can be used for a taxi or an Uber or bus fare or a driver. So the answer is yes, the funds can absolutely be used for transportation.
Fantastic. Is it better to have a local person managing a trust like this or someone that's out of state? Does it make a difference?
Number one, as long as the person is a resident of the United States, they can manage it. I mean, it just depends. Ordinarily, I'm a fan of, if all other things are equal, let's pick somebody local just in case something needs to be done that's kind of local in nature. But in this day and age, with so much is done online, look at us. So much is done through Zoom, telephone calls, scan and email. I don't think it's that big of a deal. I mean, if somebody lives here and they have a special needs adult child and they want their son who lives in New York or Seattle to be the trustee, and that's the best candidate for the job, I don't see it as a problem. So I don't think it really matters that much, honestly, in today's world.
Okay. So the free consultation, I did have someone ask, is that done in person or can it be done over the phone?
Okay. So prior to COVID, we really encouraged people to come in person, simply because we find that things go better, and I think for everybody, it's just a better way to do business generally. Of course, with COVID, we had to especially because I have a lot of seniors. I mean, not all, but a lot of seniors are my clientele. We had to completely restructure that, and we started doing more over Zoom, over phone calls. We took a lot of protocols for the people that did come in the office. Now, I mean, I don't know really where we stand, but it seems like things are getting a lot better. Now you're hearing more stuff in the news, but a lot of people want to come in. So I have a lot of people coming in. But if you really feel like, you know what, I'm not comfortable coming in right now, I'm still not getting out and going places, we can do a Zoom or a phone call. Zoom's better than phone. The more personal it can be, the better. But so we like people coming in person. If you don't want to do that, we'll certainly accommodate another way of meeting.
Okay, perfect. So this person said they have an adult son with special needs, and they have a special needs clause in their living trust. His brother is supposed to distribute the money. So what happens if they decide not to give his brother the monthly stipend? So what happens if the money doesn't get distributed the way that it's supposed to be by the person managing the trust?
Okay, number one, let me say this, and then I'll address that. It is dangerous of me to address a legal document without having read it.
Right.
It's very dangerous. So I'm just kind of going on what is just being said here. So I can't guarantee I'm right because I don't know what the language says in the trust. That being said, number one, if the trust tells the brother to give monthly distributions, if that goes to the beneficiary, that's terrible. That you're not allowed to do that. They're going to, eventually that Social Security is going to see that in the banking records when they do their annual review, and they're going to probably kick that person off of Medicaid and Social Security until all that money is spent down. So if it says to give monthly distributions to the special needs person, that's really bad. You need to have that redone. If sometimes I'll see a trust that says, you know, this John Smith is not the beneficiary. The beneficiary is a special needs trust created for the benefit of John Smith, but the trust doesn't exist yet. Then the trust can then be created by the successor trustee. So if you say, well, I'm not supposed to give it to John, my brother, because he's special needs, and it says to give it to his trust, but I don't see a trust here, then that brother can go ahead and hire a firm and have that trust created for him, okay? But it's generally better to have that done ahead of time. If you really want to help your family out, most of my clients will go ahead and just get all that, their bases covered, just to make sure everything goes well and goes smooth and there's no hiccups.
So what I'm hearing is it's probably best to have those documents looked over and make sure it's the best arrangement for everyone.
To that family, I would say for sure, let's review that and see, you know, if it's me or if you already have an attorney you work with, I'd be happy to look at it, but I'd want to read the language myself before I gave a for certain comment.
Okay. That makes sense. That definitely makes sense. Barb's iPad, I see you have your hand up. Is there a reason for that, or did you do that by accident?
I did it on purpose.
All right. Well, I noticed it.
Okay, this is really important. I have a special needs trust for my son. He's 54. He's on Medicare, but not Medicaid. So how does he get? He only gets $1,400 a month, for crying out loud. How's he supposed to live and eat on it?
So number one, okay, with Medicare, the inheritance will not impact Medicare. That's number one.
Right.
Medicare is different than Medicaid.
Right.
Number two, Social Security. Does your son earn any income? Because some people will get SSDI, but they still have the ability to do a little bit of work, but there's kind of a sliding scale of how much money they get from Social Security and how much they can earn.
Well,
is that the situation with your son?
Yes, but he really can't do it. So he just has SSDI.
Okay.
Because he really can't do anything.
Does he live with you right now?
No, not right now. No.
But is he currently making his ends meet on $1,400?
Yes, but I help him.
Okay. So, I mean, basically, I think the way we would look at it is that the trust would have to step in and be the one to help once you're gone. And believe me, I understand, you know, like the question earlier, why can't we pay for food. and clothing and shelter? And because the check may not seem like it's a lot, and we can, you know, buy these other things with the trust, but why can't we buy food or get a little bit nicer apartment? I don't have the only answer I can give you on that is that's what the government says. So it's what has to be done.
But I was told to get this special needs trust because he was in the hospital for 1.5 years with no insurance. He has insurance now, obviously, met SSDI, but I was told that if I left him money like a regular person, not in a special needs trust, that the government would take it away to pay the old medical bills.
That could be true also, yeah. So number one, I generally come at this topic more from the standpoint of once you pass away, we want for the trust to be able to help your son
Okay,
pay for some things while he still gets his SSDI and his medical coverage. But to your point, it's a good point. I just don't, it doesn't normally come up. If he already has existing medical bills out there, and he receives an inheritance from you that's not into a special needs trust, it is true that the lien holder could come in and capture part of the inheritance or all of the inheritance to
right.
pay the debt owed to them. So that is another good reason for him to have the special needs trust, is to prevent that hospital from taking his inheritance.
Okay, because
So
I
it's
was
kind of like your son
was-
has two good reasons to have that trust rather than just
There you go.
one.
well, that's why I have it. But I was hoping that it was more like, what do you call it? Like an UTMA, where it would pay for for education, food, and whatever. I don't know.
So it can
I'm
pay
just a
for,
little surprised.
it can pay for education, but it cannot pay for food, shelter, clothing. And again, it's just kind of, hey, don't shoot the messenger. That's what the government has decided. So
Right.
I'm sorry
But how-
about that. I don't think it's 100%. Like, I think there needs to be restrictions again, so we don't have the person living in a mansion receiving Social Security.
Right.
It's a waste of government funds, but I think I would like to see that relaxed a little bit, maybe provide people with a better quality of life, but it just hasn't happened.
When you talked about stuff like paper products and things like that, how does the trustee pay it? I mean, you're telling me that trustee somehow has to transfer pay Amazon or pay, how does that work?
So yeah, if I'm a local trustee and I want to, the trust has a bank, the money is in a bank account, right? So there's a bank account in the trust name. And so I have a debit card, just like I would for myself. I have a debit card in the name of the trust. And I go to Sam's and I use that debit card and I buy the toilet paper and the paper towels and the cleaning products, and I take them over to that person, to the special needs person. Or like you just said, maybe if I'm out of town or if I just don't want to go to Sam's, I order products online and I have them delivered to that person. Yeah, the money can't touch their hands.
Right, but why can't he order it with the debit card through Instacart or something?
Because he's not the trustee, so therefore he's not supposed to. Now, could somebody do that? Could somebody get online and order it, use the debit card for the trust, and have a decent chance that Social Security is never going to find out? Yeah, maybe, right? But if you're going to do things by the book to make sure that that person keeps that trust intact and they don't lose their disability, it needs to be the trustee. That's just the rules. It's not the beneficiary is not supposed to have direct access to the money, not to cash, not to a card. It's all supposed to be the trustee paying for it and then giving the whatever's purchased to the beneficiary.
I understand all of that, but the trustee that was set up by the attorney is in a different state. I've never heard of them. I've never spoken to them. I don't know anything about them. He's never contacted them. So what happens? He just starts working with them when something happens to me. Somehow this all just magically happens.
So this is my opinion, and I would say this: if somebody came into my office with an out-of-state, it said, I don't live in this state and my son doesn't live in this state, but we want to use you. So people should not be using out-of-state estate planning attorneys. Estate planning laws are specific.
See, that's what I think too.
By state. And so if you live in Texas, you want to use a Texas estate planning attorney. It could be somebody in McAllen, Amarillo, El Paso, Texarkana, anywhere in between, but you want it to be a Texas licensed attorney. If you don't live in Texas, you do not want to use a Texas attorney. So right there, that's a red flag for me.
Right.
Doesn't mean there's anything wrong with that attorney. It just means that they may not have done things in conformity with Texas law.
Well, they did it for a reason, but I feel like what you're saying is I've never been comfortable with it for some reason. So you're validating what I'm thinking.
Okay. Well, you have the offer to, have a personal consultation with me, and I'd be happy to take a look at things and talk to you about it.
Okay.
All right. Thanks.
Well, great. Yeah, I would definitely take advantage of those free consultations. This seems like a lot of you have a lot of questions. I don't see any in the chat, but definitely in situations like this, they are very personal and they aren't one size fits all, just like most estate planning is. So that will do it for today. Brandon, thank you so much for joining us. To reiterate, his phone number over there at McGee Law Firm is 817-899-3286. You can now, yay, starting August, September, find their information also in Celebration magazine and on our website, or you can visit them at McGeeLawDFW.com and they will be there to help you. Brandon, thank you so much. As always, great topic. Yeah. Wow, I never knew. That's a lot of information and lots to handle. But great information to have nonetheless.
Yeah, thank you guys so much. And again, if any of you all want to take advantage of that consultation, just reach out to the office. They'll be happy to set that up.
Yep.
What's the phone number?
817-899-3286.
Okay.
All right, thank you guys. Have a good day.
Thanks, everybody. I'll see you on Thursday for bingo.
Thank you.
Thank you.
Bye, everyone.